Hi, and welcome to Hull and Hull TV. I'm your host, Dana O'Brien, and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull and Hull LLP, an innovative law firm with offices in Toronto and Oakville that practice exclusively in estates, trusts, and capacity litigation. Here on Hull and Hull TV, we're exploring the issues around estate planning that affect you, including common law. Ian and Suzana, when people look around at their friends and family, I suspect they already know this, but the latest census confirms it. More couples are opting to live together rather than get married. So what happens when one of the common law partners dies? Ian, it can be a real mess, can't it?
It certainly can be, and one of the misconceptions that exists is that when a partner who's in a common law relationship dies, that the surviving spouse or the partner has the same kinds of rights that you would think you have if you had been in a married situation, in a marital relationship. And that is simply not the case. Your situation in a common law relationship is much more vulnerable financially for the surviving spouse than most people understand.
When a couple breaks up, the usual thinking is, what's mine is mine, what's yours is yours. But how does it work in a common law relationship, Suzana? What's different?
Well, it is different in the sense that there are no property rights, and I think that that's sort of to draw on Ian's misconception, one of the main misconceptions people have. When you're in a common law relationship, you're looking more to create claims if you're going to against the estate, and so you're going to have to seek things like support rather than property rights. Perhaps make claims for unjust enrichment or quantum meruit or even constructive trust or resulting trust claims. Those are the kinds of claims that are available in a situation where there isn't a marriage, and so therefore you're sort of looking to create a different kind of claim against the estate.
Ian, do couples usually get something in writing before they move in together?
Well, it's a good question, and I'd like to say yes, but the truth is statistically they don't. And they don't, especially in the common law relationships, address this in a pre-relationship stage with a contract or in a post-relationship stage in a contract on a regular basis. And it's unfortunate. It can be done. It's an easy solution to sit down and determine either going into the relationship or during the relationship with some particular outline of how your estate plan is going to arrive at before through a contract, or at least transparency in some nature and some discussion between the couple so that on death, the more vulnerable spouse, and they are vulnerable legally, isn't going to be left in the lurch.
So is the solution, Suzana, an agreement? And is this more important when there are kids involved, like stepkids, for example?
I think because of the informal arrangement that comes about as a result of these kinds of relationships, that documenting the intentions is really, really paramount. You want to do everything you can to avoid having an unintended result. And so to the extent that you can plan with things like wills, with things like contracts, perhaps trust arrangements, insurance ideas as well could be applied to an estate plan. And I think that's really the best way that you can prevent anything coming about as a result of an unintended outcome in these situations.
Ian, how long should a cohabitation agreement last? Do couples do it once and that's it?
Well, I think there's two parts to that. Of course, often if they go to the trouble, and happily do go to the trouble of creating an agreement, those agreements are, in theory, established to last throughout the lifetime of the relationship and maybe the lifetime of the individual. But underlying that is your estate plan. And your estate plan, in my view, should be revisited every 5 to 7 years. And at that point, you can reconsider as well the nature of the contract. Is the allocation fair at that point? Is the relationship much longer than you had even anticipated going into the contract? And revisit some of those terms. Whether you change them or not, they can also be reflected in your estate plan.
So before couples share an address, they should share an important piece of paper and talk to their families about it. Ian and Suzana, thank you. And thanks for joining us on Hull and Hull TV.